Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39407, McKinley versus Interinsurance Exchange of the Automobile Club. Can I have entries of appearance, please? Your Honor, Linda Hill and Bennett on behalf of the petitioner Jennifer McKinley, who's in the courtroom today. Thank you.
Good morning. We have a Meadow on behalf of Amicus, New Mexico Trial Lawyers Association.
Thank you.
Good morning, Jennifer Nguyen on behalf of the Automobile Club.
James Barrett on behalf of the Automobile Club.
Morning, Your Honor. Scott Hatcher for Farmers Insurance Company of Arizona.
Good morning, Your Honors. Nina Allen on behalf of the Beach.
Thank you. Go ahead and have a seat. Ms. Bennett, it appears that you have reserved 15 minutes for your presentation in chief, agreed to share 5 minutes with Mr. Romero, and then secured 10 minutes for your reply. Is that correct? And then between insurance companies, we have a split in time, 15 minutes apiece between Mr. Hatcher and Ms. Noya. Is that correct? All right, thank you. Ms. Bennett, you can take it away. Thank you. May it please the court. Clearly, this is an uninsured motorist case. It meets all of the Brits versus Phoenix indemnity prongs, all three of the prongs elucidated in Brit versus Phoenix indemnity. The blazer was an active accessory. Without the use of the blazer, this attack doesn't happen. The assault with the knife was part of a series of events, all using the blazer, positioning, the transport, and the attempt at flight. The blazer was where the thieves fled to escape. They didn't try to go generally into the neighborhood. They went straight to the car, and it was in the process of trying to use the blazer to get away from the scene of the crime that Mr. McKinley intercepts them, and the stipulated facts show that he was injured in the blazer. So Ms. Bennett, are you asking, is it your position that Brit creates a but-for type of inquiry? Because that's, I think, where you started. But for the blazer, none of these things would have happened. I think the active accessory component encompasses that concept. I think that if you're looking at an active accessory, you're looking at what exactly is the difference between Mr. McKinley before this entire incident happens and after. And without the blazer, Mr. McKinley is alive and well. And the crucial fact there is the use of the blazer to bring the thieves to the place, to try to cache, it was actually used to cache the materials that they found.
Transportation in every circumstance in which there's a crime, all the standard needs to say is transportation. There doesn't need to be a causal link.
True. What I'm trying to say, Your Honor, Justice Thompson, is that this is part of a series of events, none of which is broken by an independent intervening cause. That's how I'm saying the Britt analysis works in this case. The Britt analysis requires the court to look at the series of events that transpired and determine, part of the second prong, if that was broken by an intervening act. And as the court knows from the other cases that discuss the shootings from a vehicle, the dog bite case where the vehicle doesn't have to be in motion and transportation is not necessarily a part of the analysis. In this case, it happens to be part of the analysis. In this case, it happens to be how the thieves got to where they could commit this act.
What act?
The act of
The thievery or the stabbing?
the thievery and the stabbing. It's all part of, if you're going to engage in an illegal enterprise, it's entirely reasonable.
But then we're back to the transportation. Every circumstance in which a vehicle is used to transport and a criminal act occurs, you've done away with Britt, to the Chief Justice's question. Why don't we just say transportation? That's not what Britt says.
I don't think that transportation is the only reference point here. We also have Mr. McKinley trying to prevent the vehicle from leaving the scene of the crime. That's absolutely a part of what all of the cases say needs to occur in order for the Britt analysis to be satisfied. There has to be some use of the vehicle.
Is it, the thing that I struggle with here is certainly if, I think it's foreseeable that, you know, if Mr. McKinley was standing in front of the car doing this and he got run over. But here he got into the car, and that is such a unique, almost bizarre fact here. That getting in the car and then subsequently being stabbed are very distinct from the enterprise at play here, which was robbery.
I disagree, Your Honor, because usually when we conceive of a conspiracy to commit illegal acts, we don't exempt the reasonably foreseeable other things that happen during those criminal acts. That's the foundation of our felony murder concept. The idea that once you have bought into a criminal activity, you are going to be held responsible for anything that happens during that action. And we're not going to let you get away with saying, well, I had no intent for a murder to happen while I was committing this burglary. Especially because in this case, they clearly were caught in the act. They didn't go there with the intent to get caught, but once they were caught, it doesn't take very long to form an intent to get away. And it is in the process of using the vehicle to get away from the scene and to prevent Mr. McKinley from either, I mean, we have no way of knowing whether he jumped in the car to try to retrieve his belongings or if he jumped in the car to try to get them to stop so that he could apprehend them. That's unknowable.
Ms. Bennett, how do you get past Crispin and Tillardo where the court said using the car for transportation is not sufficient?
Because we're not simply relying on transportation. As I tried to answer Justice Thompson.
Well, but like in Crispin, they use the car to transport a child and then sexually assaulted.
Right.
So they use the car for something else. How is that different from using the car?
True,
in
because
this
in this
stab?
case, as Justice Bacon just pointed out, we have the unusual and perhaps unique fact that he got into the car.
Mhm.
And in the same sense that I also thought of, well, will we be having this conversation and would there be any question if instead of getting into the car to prevent the car's flight, he had jumped in front of the car and the car had run him over? Would that have been, would we be having
But
this
in one
conversation?
situation, you have the car, and the other one, you have a stabbing.
Correct.
Correct, but you have them waiting until he gets into the car to commit the stabbing.
But how is that part of the enterprise? Because I can also make the argument, I'm standing in front of the car trying to stop it. They're using the vehicle to escape the scene. And that's part of their intention in the enterprise was drive there, commit the robbery, get in the car, drive away. Very clean kind of definition of enterprise. Here, the enterprise did not include this stabbing somebody.
I respectfully disagree. They brought a knife. He did, if he had died of a heart attack in the course of this, we might be having a conversation about whether it's speculative to say whether the knife was brought for that purpose. But clearly,
That's,
they brought a knife to a criminal, sorry.
I need you to clarify that
Sure.
for me, because I could not find in the record where there was evidence that he brought the knife. We couldn't tell whether he brought the knife, whether it was in the tool bag that they stole. There was nothing in the stipulation by the parties that said where the knife came from. We don't have any information on that.
Or to follow up on that, whether the knife is always there. Some people keep their firearms in their trunks at all times. I mean, so do we have, if you could clarify that?
If that is a material issue of disputed fact, we
Well,
say that.
Based on the statement that you just made that he brought a knife and stabbed him, then maybe we're talking about an enterprise and there was a plan. If he stole a tool bag out of Mr. McKinley's truck and there was a knife in the tool bag and he pulls out the knife from the tool bag, it's a harder stretch to get to that enterprise.
I disagree only because the formulating the intent can be very fast, can be instantaneous. If he's going through the tool bag and comes across something, I would follow that and say it's not a reasonable inference if he'd stabbed him with a screwdriver.
We just don't know here, right?
Exactly, and it's unknowable.
So
I
how
think.
do we deal with the fact that there are facts that we don't know that may be relevant to our analysis?
I think if that's the case, if there if there is a dispute of material fact, then the court has to remand. The court can't allow summary judgment to go forward if there is a dispute of material facts in question.
The problem I have here, though, is that these were stipulated facts. These were the facts we were asked to review. It was not a situation where we didn't have an opportunity to get to that part of the discovery. How do we deal with that?
True, but de novo review requires the court to look at the whole record to determine if there are facts and evidence. If the parties have gotten ahead of their skis, so to speak, and neither party has provided the court with sufficient evidence upon which the court can say, yes, summary judgment was properly granted or not properly granted, then the standard of review would require that the court remand the case for further hearings with regard to that. That's exactly what happened in Blystra and Britt. The court is not bound by the stipulated facts. The standard of review allows and requires the court to view the facts in the light most favorable to allowing a trial on the merits. That's the whole point of the standard of review. I'm sorry, Justice Thompson.
No problem. Other than fleeing, what is your,
Other
than using the vehicle to flee, what is your best argument that the vehicle was used to facilitate the stabbing?
the fact that the stabbing did not happen outside the vehicle. The fact that
Did they-
it's,
Okay, it
The-
happened inside the vehicle, I agree. Did that facilitate the stabbing?
yes,
He entered the vehicle.
in the same sense that the enclosed, confined atmosphere of the car that we see in Bell facilitates the attack by enclosing the defendants, and they know they know the vehicle, they know the interior of the vehicle, and they understand its scope and parameters.
Does it matter that Mr. McKinley entered the vehicle voluntarily rather than being pulled into the vehicle or lured into the vehicle?
I don't think it does for purposes of determining whether he was, the stipulation is that he was injured in the vehicle. That's, I mean.
If they're using, if I understand you correctly, your claim is that the perpetrators used the vehicle
Yes.
to stab him and he went into the vehicle. Does it matter that he entered the vehicle and then they stabbed him?
On remand, yeah, as part of the question of overall liability, that might matter in terms of contributory or comparative negligence.
But to
That's not a deciding factor with regard to what's before the court today. I don't think the parties briefed that.
Had they forcibly put him in the vehicle with the purpose of stabbing him, that's different than him voluntarily entering it. So I do think that's a somewhat significant fact, but it doesn't sound like you do.
I don't think it is, Your Honor. I think what Mr. McKinley did was, in the heat of the moment, try either to retrieve his belongings or to stop the flight of the defendants. That's all we can reasonably speculate or surmise or infer based on the fact that he was in the vehicle when he was stabbed. I think it's a reasonable inference that has to be drawn in favor of a trial on the merits that the thieves brought a knife because he was stabbed and we know he didn't stab himself, intending to use it if they were somehow apprehended and needed to defend themselves to try to get away. And we know that because that's exactly what they did. So that's a very reasonable inference. And I disagree respectfully with the Court of Appeals determining that we can't go there. I think that, again, if he had died of a heart attack due to the stress of the incident, I think that might be, then it might be more attenuated. But here, I think we have sufficient causal nexus between the use of the vehicle to flee and Mr. McKinley either trying to stop that flight or trying to interfere with the flight to retrieve his belongings in some respect.
But that doesn't break the causal link.
That does not break the causal link. So I think that the court knows the cases that indicate that, shooting from a vehicle doesn't break the causal link. But, again, I think that parsing all of the different fact patterns, which Britt tells us we have to do, these are inherently fact-related issues, means that although these are unusual facts and perhaps, hopefully, unlikely to occur again, I do think that the facts require the court to look broadly at the enterprise that the defendants were in and see the actions of the defendants in the back of the car.
Did their enterprise include stabbing people that happened to come upon them in the act of committing these burglaries? What
may
evidence is there of that?
They are engaged in a criminal enterprise. They're clearly there breaking laws. They are clearly there intending to steal things, and they take responsibility for what happens as a result of that. They're both in jail
Okay.
as a result of these actions. My time has expired. Thank you.
Justice of the court, may it please the court. The three-pronged Britt test should be modified to only include the first prong in order to comply with the plain language of the UM statute and align with case law from this court, which has broadly construed the UM statute, consistent with the remedial nature of the UM statute. The court should reach this issue and correct the test through a de novo review and pursuant to Rule 12.
Do you know of any other states that have adopted a similar test that you're proposing today?
I am unaware, Your Honor, but I'm also unaware of cases that have consistently referred back to the particular expansion of the statute. Cases that have consistently held, like we did in Jordan versus Allstat, Markstat, and even Britt, which says the statute in New Mexico, the legislature chose specific language and requires a qualitatively different analysis.
Doesn't it also contemplate reasonable limitations? It doesn't say this is just a free-for-all. And that expansive view is largely found in the definition of accident. That's where the expansive view comes into play. The statute also contemplates some restrictions so that it is not potentially as broad as you're advocating for.
Correct, Your Honor. But we're not asking for overruling Britt. We're asking for modification of Britt because the first prong does provide a sufficient cabin for the test. As the argument so far today has really focused on the first prong, because the first prong provides a sufficient cabin. First, we have the sufficient causal connection between the use of the vehicle and the injury. Then we also have the active accessory language in causing the injury. Those two questions are provide those limitations, and it provides a clear language, which, as Britt itself recognized.
So it doesn't matter if the vehicle is not put to normal, it's not some kind of normal use or expected use.
At that point, it starts limiting language and qualifying language to the statute that is not there. What the statute requires is arising out of ownership, maintenance, or use of the vehicle. Prong 1 stays true and faithful to that language by asking whether there's a sufficient causal connection between injury and use and active accessory by qualifying.
You know, we do have a case where the court found that a car was not put to its normal use when it was used as a gun stand. How would that case come out consistently if we were to eliminate number 2 and 3, or would it come out differently?
We would need more facts on that point, Your Honor.
Car's parked, guy gets out, levels his gun on the hood of the car and shoots someone. Is that an uninsured motorist claim?
Again, it depends, Your Honor, because what prong 1 asks, and consistent with the remedial nature of the statute, is expanding the inquiry, not just the particular moment in time of getting out of the vehicle and shooting somebody, but how was the car used? What is the causal connection between the use and the injury, and was the car an active accessory? Is this a situation where the vehicle was used to track and follow another?
But if we adopted the proposed test you're advocating for, wouldn't we get closer to having concerns that Justice Thompson raised about anytime you use the car for transportation and a crime ends up being committed, once you're there or once you get to the scene or wherever you may go? I mean, aren't we getting to the point where almost anything would be covered?
Respectfully, no, Your Honor, because that circumstance, prong 1, we already know the results if it's really just going to be interpreted as a transportation or a situs test, which is not what prong 1 is. Crespin provides us that analog, which is it cannot be just a transportation. It cannot just be situs. It has to have some larger causal connection between how the vehicle was used in relationship to the injury. In that circumstance, it really was just used for transportation, and there was no connection. And with respect to prongs 2 and 3, we contrary to the remedial nature of the statute, it limits it. And we see that from Britt itself in paragraph 16, which says prong 1 is clear. When we analyze prongs 2 and 3, the Supreme Court said it becomes less clear, and that is the issue with prongs 2 and 3, is it is unclear. Thank you, Your Honor.
Know who's going first, Mr. Hatcher.
Morning, Your Honors. May it please the court. I'm plan on focusing, because I was trial counsel, primarily on the facts. My colleague, Ms. Noya, will try to address some of the concerns that this court has already raised about the issues raised by the Trial Lawyers Association in their amicus brief. What I heard in the presentations from the appellant so far is that the elimination of what they want to do is basically eliminate any type of proximate cause analysis. In other words, they want, as has already been discussed, they want a but-for test. And that is, so I think we can assume that if the Blazer had not been present, there wouldn't have been a stabbing in the Blazer. But there's a difference between causation in fact, which is kind of a but-for test that's being advocated, and proximate cause. We have not eliminated, by enacting the Uninsured Motorist Act, we have not discarded any traditional notions of proximate cause. That's why you have prong 2, because even today under 13-305 in our UJI, it defines causation as a causation basically in fact, unbroken by any independent acts of significance. So I think the way to evaluate this case is to define, as the Court of Appeals did, what is the use that is being purported in this case? There are basically 3 primary uses that throughout, from the district court on up, the appellant or the plaintiff has argued. 1, the Blazer provided access to weapons. 2, it was the structure of the Blazer to facilitate the stabbing. That was use 2. And then the final primary use is the use for fleeing. So I think the Court of Appeals had the analysis, or the structure of the analysis, right. Identify the uses and then determine from the stipulated facts in this case what whether those uses facilitated the harm in this case. So as we recall the Haygood case, it's very similar in terms of the factual circumstances where there was a stabbing inside a vehicle. What the Court of Appeals did in Haygood, they asked, 1, what is the intended use in the assailant's mind? Well, the intended use was to store drugs in the glove compartment. And then the second issue, did that use facilitate the stabbing that occurred in the vehicle? In that case, you recall that the assailant came out of his house. The car was parked in front of his home. He attacked a passerby on a sidewalk. The altercation ended up in the car and a stabbing occurred because the assailant thought that there was a issue with thieving the drugs. But there's no evidence, the Court of Appeals found, that the assailant intended that use as a facilitation for some harm down the road. And similarly here, it's already been brought up by your honors, if you look at the first purported use, the access to a weapon, we have no evidence, and there never would be any evidence as to where the use or where the source of the knife came from. We don't know if the knife came from the thieving activities, whether it was part of the loot, whether it was on one of the Hernandez defendants from the beginning, or whether it was stored in the glove compartment.
Would it matter if in this case, the victim was lured into the vehicle?
If the victim was lured into the vehicle, I don't believe so, Your Honor, because there was never an intent. And the second point I was just about ready to make.
But if they lure him into the vehicle, there's an intent to do something.
There's an intent to do something. And if they, let's say they lured Mr. McKinley into the vehicle and then put him in there and knew or anticipated that the structure of the vehicle gave that vehicle an advantage to carry out a stabbing, it might be a closer case. But we don't have that. We don't have those facts. And as the briefing has stated all along, these facts have been stipulated too. There was no attack.
I appreciate that, but we have to write a rule that's for all cases, not just for this case. And that's why Justice Vargas, in large part, is probing what are the edges of this.
So that goes really, Your Honor, to the second purported use is the physical characteristics of the vehicle. Again, There is absolutely no evidence to determine, for this court to say, or any court to say, the physical characteristics were intended by the assailants to facilitate the harm. Now, the appellant spent 2.5 pages in briefing on the issue of I think it's State Farm versus Bell. Now, the Bell case is quite different, and it should be contrasted with the facts in this case. In the Bell case, you had, if you read the opinion, and I know you have, the plaintiff had expert testimony from a veterinarian who testified about personality and characteristics of dogs when they are confined. In that case, there is no potential that the dog would have bitten the little girl had the dog not been confined. Contrast that to this case. This incident could have occurred anywhere. This incident could have occurred in the Blazer, the stabbing could have occurred inside the Blazer, it could have occurred outside, could have occurred at any point after Mr. McKinley was alerted to the thievery or the burglary of his vehicle, and presumably they ran down, he was chasing them down the road or the driveway. Could have happened at any point. So what we end up here without any evidence that the vehicle was intended to be facilitated to cause harm, we end up with basically the Blazer being a mere situs of the harm, and we end up with just an ugly act of stabbing an innocent man, similar to what we had in the prior case that I was discussing, the Haygood case. The final purported use is the use for flight, and there's a strong argument made by the.
It is strong. Whoops, I'm sorry. Learn to use my mic.
I didn't mean it was strong.
Well, I did.
I meant they think it's strong.
Okay, I might also. So, because you could almost view this as two circumstances, one in which there was a theft, and then there's a circumstance in which they are now in the situation which he has entered the car, and now they're doing a separate act, which is fleeing. And that is where the act occurs in order to prevent the fleeing. Not any different, I'm sorry, from the Chief Justice's example of standing in front of the car.
Your Honor, I think there's no question that the intent of the assailants was, with respect to the use of the Blazer, was to flee. There's no question about that. They parked the Blazer out toward the road. They intended to make a quick getaway in the Blazer. There's no question. I would turn this around as the Court of Appeals did, and I would say that the intent to flee in the Blazer was interrupted by the act of significance of the knife attack. So that triggers the second prong if the use is considered a valid use for a Brit test of fleeing. So I want to distinguish a couple of other cases that have been cited in the briefing from what we have here. Again, it's our position that the Blazer here is simply, as in Haygood, just the mere situs of a really horrendous, terrible act. The Blister case is a 10th Circuit case, but it was one of the earlier cases that talked about Brit. And in Blistra, we had a drive-by shooting. There's no question that the use of the vehicle facilitated the harm. You had facts where in fact, I think the 10th Circuit said almost by definition, there's an use to facilitate the harm because the vehicle is used to make a quick attack, to hide the identity of the driver, to hide the identity of the arms. We don't have that in this case. There's nothing there's no facts or inferences where the Blazer did anything to facilitate or create an advantage for this particular stabbing, which was really, if you look at the stipulated facts, a spontaneous act of simple self-defense. These assailants, bad people, but they were acting in self-defense, trying to save their skin at the expense of Mr. McKinley. The other case that I think is worth contrasting these facts to is Barncastle. And Barncastle is a case where it is a good example of the demonstration of the advantages used. The Crespin case actually, in terms of the advantages used to facilitate an act, Crespin describes the use of the weapon, or I'm sorry, as the vehicle almost as a weapon. In Barncastle, that's what you had. You had a vehicle that comes up, sneaks up behind at a stoplight, the victim vehicle, and they positioned the vehicle to basically allow a quick escape by the victim vehicle. An occupant comes out, goes up to the victim vehicle and shoots one of the occupants. You have a facilitation or the use, as in Crespin, of the vehicle essentially as a weapon. There is no fact here today in this particular case. I would finally, Your Honors, I think there's a problem both with the use prong, and I think there's also a problem with the second prong of Brett as applicable here. You have, in this case, the facts show that there was uses of the vehicle, burglary activity. You had Mr. McKinley's confrontation of the assailants as they were burglarizing his Toyota. You have the chase down the driveway. You have the altercation, which from the evidence shows that it probably started outside. There was evidence of blood smatter on the outside of the vehicle. From the facts, it's a logical inference that the altercation then was pushed into the Blazer, and then we have the
What
stabbing.
about Ms. Bennett's argument that we have to capture everything that is foreseeable as a result of engaging in the burglary itself? And that there need to be logical consequence as a result of that foreseeability.
Logical consequences from the standpoint of the assailants.
I'm trying to interpret Ms. Bennett's argument that it's foreseeable that somebody would notice they were being robbed and a chase would ensue. And why isn't that continuum of activity, as Ms. Bennett would put it, reasonably encompassed here?
Well, I would argue that the facilitation or the use of the vehicle comes not from Mr. McKinley's point of view, but from the assailants. Otherwise, there's no use of a vehicle to advantage their acts. But if we're talking about each of those facts as a continuum, I would argue, Your Honor, that each of those, the burglary activity, the confrontation, the chase, the altercation and the stabbing, each one of those are acts which are of independent significance, which break that causal chain between use and the harm. Does that answer your question, Your Honor?
I'm not sure, but I don't have a better way of asking it.
Okay.
What about the fact that the SUV is pointed to the street? It's backed in. You said it's limited to an inference that quick escape. But isn't it also an appropriate inference that them doing that, they recognize that somebody may interrupt their burglary and they need to get to escape, and that they may be interrupted in their attempt to escape by the acts of a homeowner, either with a gun or jumping in or whatever the situation may be, but they anticipated by parking it in that way that this kind of an altercation could have taken place.
Well, certainly wanted to get out of the area quickly, but Your Honor, I respectfully don't believe that that's a reasonable inference that they anticipated that someone was going to, they may have anticipated, Your Honor, that someone was going to surprise them or catch them in the act, and
that's
an
why
altercation would occur. Our point is that there was no anticipation that the altercation, or in this case, the stabbing, would have actually occurred in the vehicle. So there was no intent or reasonable foreseeability by the assailants that they were going to use the physical characteristics of the vehicle to stab. Yes, they were anticipating using it to flee. But again, I repeat what the Court of Appeals said earlier, was actually the stabbing that breaks that causal link between the intended use to flee and the actual.
Why is stabbing different than running over the homeowner standing in front of the SUV?
Because there's simply no, under these facts, running over is a different case, Your Honor. If they used the vehicle to run Mr. McKinley over, that's a closer case. Here, what you have, the only possible use under these facts in this case is they're arguing it was the physical characteristics of the vehicle. The argument is we took advantage, the assailants, of the physical characteristics of the vehicle. That's a different case from running over. And for our case, there is absolutely no evidence.
Mr. Hatcher, your time is well
I'm sorry,
expired.
there is no evidence to support that intended use. Thank you, Your Honors.
Ms. Noya.
Good morning, may it please the court. I'd like to, let me pick up just for a minute where you left off with the question, Justice Vigil, about running him over. If the vehicle had ran Mr. McKinley over, this would be an entirely different case. Getting run over by a motor vehicle is a hazard of motoring, and it's what is encompassed with the Uninsured Motorist Act. So I think that's a very different circumstance than was our legislature intending to regulate and provide coverage for instances when crimes take place and people are stabbed. And those are unfortunate, it's terrible that these things happen. But our legislature, when they enacted the Uninsured Motorist Act, it's part of the Motor Vehicle Code, and the intention is to protect from the hazards of motoring. And that is not what we had in this case. Now, since my colleague addressed the particular facts here, what I'd like to do is talk a bit about the framework from Britt.
Where has Britt failed? That's my question is, we don't have it's an old case. We haven't seen a lot of these. I handled some at the trial court. I don't know where it falls apart. I don't know the need, or can you address, have there been any other states that have either altered Britt, or has Minnesota or Colorado, upon which Britt is built, changed their view?
And that's a very good question, Justice Thompson. And Britt hasn't failed us. The law regarding uninsured motorist coverage was broad back when Justice Minsner wrote that opinion, and she recognized that. I think that opinion's 18 paragraphs, little numbered paragraphs, and I think 5 times she points out the UMA is broad. It's to strike this broad remedial purpose. The cases that the court looked to, both Klug, the Minnesota case, and as well as Kuhn Law out of Colorado, those have been criticized not for some narrow restrictive opinion of what uninsured motorist coverage is, but exactly the opposite. And no case has adopted what is being argued here today. As I understand the argument by the amicus, the trial lawyers, they want this but-for causation kind of standard. We're gonna look and say this activity of these two thieves going out and thieving and driving and using a car to get to the location of the thieving, and then storing stuff in the car and then driving away, somehow turns this into an accident under the uninsured, under the coverage that's here.
But Ms. Noya, isn't Mr. Romero's point that there still needs to be proof that the vehicle is used as an active accessory protects against that?
No, because that's what Justice Minsner in the first part of Britt recognized, that the vehicle, it had to be the sufficient causal link, and that's been interpreted to the vehicle being an active accessory. And she found in Britt, those facts that the car had rammed, they stopped, and then there was an altercation. They found that that was sufficient for part 1. but the inquiry needs to be on whether there was this act of independent significance that broke the link. Because it's a very different situation. If you have a motor vehicle and I'm in my car and I'm driving along and I recognize the people in front of me and I don't like them for some odd reason, and I'm gonna ram them I'm gonna take my vehicle, ram it into their car so that it'll require them to pull over so I can then stab them. Though that's a very different loss facts to the situation they had in Britt, where they couldn't tell why this initial injury took place. And that it's essential in order to keep that causal link to have that the accident actually arise out of the use of the motor vehicle. You have to look at that and examine it. And it's not every time I use a car and drive someplace and commit a crime and I flee in a vehicle. The UMA simply wasn't designed to cover those sorts of circumstances. I mean, under the interpretation of the estate and the trial lawyers, it would cover, for example, a burglary. I'm a bank robber. I go to the bank. I take my gun, which I always keep in my car. I take it out of the glove box. I go inside. I rob the bank. I run into some poor customer coming out, and I shoot him, and I jump back in my car and leave. That is not something that's been intended to be covered under the motor vehicle code. And we've had lots of cases since Britt, and we've had lots of decisions. I think Britt has been cited 56 times, and those have been both for New Mexico state courts as well as the federal courts have used Britt. In those 56 times, I went through those cases. Some of them cite Britt for, about as an arbitration award, appealable, that sort of thing. So I'm going to toss those out here for a minute. But of those 56 decisions, 17 of them are where the courts employed the Britt framework. And actually, I thought it was kind of interesting because we have Justice Bacon was on the district court for Haygood, and then Justice Vargas was on the Court of Appeals when Haygood, that opinion came out, and I think Justice Vigil was on Crispin. So none of these courts, in their opinions, have said, oh, wow, this Britt test, it's really unworkable. It's really difficult to manage. We can't figure out what we're supposed to do with it or how it implicates coverage or not. The opposite is true. And it's really interesting because we have, I thought this was interesting anyway, we have 2 of those Court of Appeals decisions came out on the very same day, back in 2000. And Judge Sutton did them both back then. And in one, he applied the framework, concluding that the accident did arise out of the use of a motor vehicle. That was in the Barncastle case that involved the shooting. And the other one was Farmers versus Cedillo. And in the Farmers versus Cedillo case, we had a situation where a motorist came into a parking lot, drove really recklessly by some children, and we had a parent that got very upset and approached the motorist, and then there was a physical altercation. So I point this out because courts are applying the Britt test. They're reaching results that make sense as far as when you can say that the vehicle was actually, that the accident actually arose out of this use of the vehicle and could be considered a motor vehicle accident, and when it can't. And there's been no case, not cited in the brief, not discussed here today, no case whatsoever that has adopted this but-for causation analysis that's being advocated. And that's really important because what I think Britt did to begin with, it started out with this broad proposition that, well, we're not even going to look at these intentional these intentional situations. We're not even going to say they're not accidents because somebody intended. We're going to look at them from the standpoint of the injured party. And that, frankly, that's broad to start with. They're saying it doesn't matter that somebody intended to shoot this person. If it meets these other factors, we're going to call it an accident, and we can go from there. So to begin with, the premise of Britt is from very get-go, it starts out broadly. All 3 factors are essential to determine whether this really is out of the use of the motor vehicle? Or is this just a horrid, awful crime that happened? And unfortunately, the problem, I mean, it is tragic. This is an awful crime, and there's no dispute about that. But not every crime falls within the Underinsured Motorist Act.
You know, Ms. Noya, one of the challenges that I found in reviewing Britt and looking at the cases that rely on Britt is figuring out exactly what the parameters are that I'm supposed to be looking at when we talk about the causal connection between the use and the harm. And we heard a little bit of this from Ms. Bennett, who talked about this being like an overarching plan by these assailants to go out and rob and pillage for the evening. And one of the difficulties I find is, when do you start looking at what constitutes the use? Do you start from when they leave their house knowing that they're gonna hit 10 houses tonight and whatever happens? Do you start from when they back their car into Mr. McKinley's driveway? Do you start from when Mr. McKinley comes out? When are we supposed to start looking at what the use of the vehicle is?
I think you have to, Your Honor, I think you have to look at the use, compare it to the injury. What we have here, they use their vehicle to go thief. And there's no dispute to that. But there's been no evidence that they somehow used their vehicle because they wanted to go stab Mr. McKinley that night. So I think you really have to look at how the vehicle is connected to the injury. And here, the record, there's blood in the vehicle. He could be stabbed in the vehicle. He could be stabbed on the porch of the driveway. Either one, they're both horrific.
So let me give you a hypothetical and let me see how you tell me this should be analyzed. Let's say there's someone who is intent on going out and sexually assaulting a woman at a bar. And before they leave, they go to their car and they implement the child locks on the car. And they go to the bar, they have a lovely evening, they find a woman that they're going to assault, lead her back into the car. They've locked the doors and they assault her in the car. Maybe they even drive her somewhere else before they assault her. When do we start looking at use of the car? The harm doesn't happen until he's driven her off-site and taken her somewhere else. But when do we start looking at the use of the car?
On the use of, and that's actually, there have been cases that are close to that. We have sexual assault cases in other jurisdictions that have talked about if you use the vehicle to, like, say, park it super close to another building or whatever to prevent a door from being opening. That is a closer call, Your Honor, because that is not the facts we have here.
Right, but this is the problem I'm running into with Britt. And as we think about how we're gonna write the rule, whether we should consider Mr. Romero's proposal, whether we should write something completely different, whether we should clarify Britt, how do we write the rule that accounts for not only this circumstance, but the one that I just told you about?
Well, and the one that you just told me about, Your Honor, first of all, I don't think you need to rewrite the rule. I think Britt has been applied numerous times, and that rule is clear about what it says. And I think this is just another Britt case, and these facts, you can apply the existing Britt test to these facts. With the example Your Honor just gave me, I think under the Britt test, that would probably fall within the UMA, because you had the use of the vehicle here. There was no independent act because that guy went out and he was making sure all his child locks were working so that person could not escape. You had, they park it right to a building to prevent her from actually ever leaving. And where I could quibble with you is on the normal use standpoint. I think you could argue that it's not a normal
Doesn't the
use of your
statute just
vehicle.
say use, not normal
It
use?
does say use, but if you're gonna give this broad construction to what an accident is, I think you still have to tether it to a normal use of a vehicle. Because I think when Britt looked at these accidents and saying, I'm just gonna look at it from the standpoint of what happened to this person, they sort of untethered it a little bit from the act itself. But where they brought the motor vehicle code, but where they made sure it didn't run astray and start covering all the burglaries and, you know, cars get used all the time. If you want to say it's a chain of events, I mean, you're opening up the floodgates, and nobody frankly will be able to afford coverage because of what it would do to the premiums. But back to that question, where I think it's the normal use part. And so I think I've seen cases that argue it both ways using this kind of Brit analysis too. So
I guess where I'm still struggling is how do we explain this? How do we explain this to all of the lawyers who are arguing these cases and applying this law when we write an opinion on this case?
because the car cannot just be incidental to this harm that happened. And in the rape case like that, like you just mentioned, I don't think that's really what the UMA was designed to protect, was victims being raped in vehicles. I think that is really a stretch of it. Have I seen courts employing the Brit type analysis and saying, well, maybe it did? We have some opinions, frankly, that are out there, I think, have provided coverage where the parties never contemplated in the contract.
Justice Fergus's hypothetical, the car is being intentionally used to facilitate the crime.
And you're exactly right, Justice Bacon. In a situation like that, in number two, you don't have nothing interrupted the chain, the link. I think an argument could be made, the normal use is not to rape people in vehicles. And I've seen that, that argument be made in those type of cases too.
Thank you, Ms. Noya. Your time has expired.
Thank you.
Thank you. May it please the court. I think the problem that certainly I, and perhaps based on the questions some of the justices are having, is, okay, so it can't just be transportation. Transportation by itself is insufficient, and it can't be the situs of the crime. So what is it? How is it that some courts have determined that the car is intrinsically related to the crime of shooting from the vehicle? But here, what we seem to have is a shooting that happens over a long period of time. I think the fact that Mr. McKinley was injured in the vehicle is a significant fact that separates these from the rape case. Although in that case, I would think that if your hypothetical included that he got her into the back seat and then employed the child locks to prevent her from leaving, and then suddenly now we've got a situs problem. So I think
I think the word is mere situs.
Mere
situs. So it's not situs generically, mere situs, the using,
right,
storing drugs in the vehicle or using it as a prop for a gun is different than the rape case, which is intentionally using the vehicle to perpetrate a very specific crime.
A kidnapping and
a sexual
transportation
assault.
for services. But I think that perhaps what we're all getting hung up on here is, and it again relates to my conception of this as an overall series of events, the stabbing of which is one, and they are all related to the vehicle. The vehicle is not merely transportation to and from the event. The vehicle is used to facilitate the criminal acts of the defendants, and stabbing Mr. McKinley is just one of the many criminal acts that occurred that night. So making that and seeing it in the broader sense, I think helps us to see that an uninsured vehicle becomes an accessory. It is used, it's the use of the vehicle that differentiates this case from the cases where the vehicle just goes to a place and then a crime is committed and it's not related to the vehicle. Justice Vargas, you're looking at me.
I want to ask you kind of a different question. I am still struggling with when do we define the term of use, but I haven't heard you say anything about the position of the trial lawyers and what your position is on their proposal to amend or change Brit.
I very much respect and appreciate the trial lawyer's perspective. We believe that we win under Brit. We believe that the Brit factors apply. We have the law as we have the law. And applying the Brit factors as have been, as I enunciated earlier, I believe that we check the 3 boxes that we have to check. I think perhaps what the trial lawyers are saying is not necessarily that we need to change things, but that we need to adhere to the statute. And that Brit jurisprudence seems to be engaging in, fine tuning and adding requirements that the statute doesn't have. And it's, something of a caution to the court that it is the legislature that makes the law, and to ensure that following that Brit's limitations on when coverage applies and when it doesn't run afoul of and add more problem or more requirements to the statute than are already there, especially given the broad policy of ensuring that people who are injured due to uninsured motorists are able to be compensated for their injuries. I'm gonna leave time on the clock. That doesn't usually happen unless there are more questions. Thank you so much for your consideration of the case.
Thank you. Many counsel, thank you for your arguments here today. The case is deemed submitted as of today, and we'll get you an opinion as soon as practical. Thank you so much.
I the court.